Hello and welcome again. My name is Alex Magaisa, and it's been a while since I did a podcast. So much has been happening in Zimbabwe, which has occupied my time and mind, and I've been doing a lot of writing in the big Saturday read. But I thought I should come back and give you a podcast with some of the big issues that have been happening in Zimbabwe lately. Today I'm going to be focusing mostly on the case of political prisoners in the country. The two most well-known names that have been spoken about in the last few weeks are investigative journalist Hopewell and a political leader, Jacob Ngarivhume. There is also another young man who has been languishing in a prison in the town of Masuku. His name is Godfrey Kuraone. He is of the MDC Alliance. The material in this podcast is going to focus mostly on Hopewell and Jacob Ngarivhume, but it applies with equal force to Godfrey Kuraone's case and a number of other political prisoners who may not have featured on the political radar. So many of you who are listening to this may have heard of the Zimbabwean Lives Matter hashtag that's been trending on social media for the last couple of weeks. This hashtag followed demonstrations that were thwarted by the government on 31 July 2020. The thwarting of these demonstrations was accompanied by use of excessive force, use of soldiers and riot policemen. There were also abductions and torture. Some of you may have seen gruesome images of a young man in Bulawayo called Tawanda Mcheiwa. He is the nephew of an investigative journalist, Mduduzi Matutu, who edits the zimlive.com news site. When the police came looking for Mduduzi Matutu, they found his nephews, whom they took, and Tawanda Mcheiwa was one of those who was abducted and tortured for a few days before he was dumped near his home. The doctors fear that he may have suffered kidney failure as a result of the severe beatings and torture that he received from agents of the state. They also took his sister as a way of drawing Matutu from his hideout. Matutu had to go into hiding in fear of his life and loss of freedom. But more than a week before the 31st of July demonstrations, the police had raided the homes of two people who were closely associated with the demonstrations. That is Hopewell, who was reporting on the demonstrations, and Jacob Ngarivhume, who was the first political leader to call for the peaceful demonstrations. They were raided on the 20th of July in the early hours, and in one of the incidents, in the case of Hopewell, they actually broke a glass door at his house as they forced their entry. In short, it was a very aggressive arrest, which was accompanied by a number of illegalities. The arrests were essentially a preemptive strike to try and dissuade people from engaging in the 31st of July demonstrations, and just to show the force and the power that the state was able to wield against those who were planning to participate in the demonstrations. The law enforcement authorities also carried out extensive searches in the homes of the detainees and seized a number of documents and equipment, including video cameras. Now, in normal cases, normal as in the Zimbabwean authoritarian conditions, what would usually happen is that when the state arrests a person, they'll keep them for a few days in the filthy cells and maybe deny them bail once, and after a few days they would allow them to go home. Give them bail with some strict conditions, including taking their passports and including asking them to make regular reports to the nearest police station. And in recent cases, they've added a new condition, which is to gag the suspects by stopping them from participating in social media. Thereafter, the suspects would come to court from time to time on remand. They would be remanded out of custody on several occasions. Their lawyers would probably be applying for them to be removed from remand, but the state would delay, keep the matter going for some weeks, often months, and sometimes often years. And this is the case in the most recent one involving the 7 suspects who were accused about 15 months ago of having undergone training in the Maldives. They had gone there for a training session on civil society activities, but when they came back, they were arrested. There was a lot of drama that they were being trained in order to fight, in order to overthrow the government. The government made a meal of it, and these people were kept in custody for quite a few weeks. But only just this week, the 7 accused persons were removed from remand by the court, essentially because there was no case against them. There was never a case against them. And it was all gamesmanship by the state. So this is what usually happens. There are several other prominent figures, including Pastor Ivan Mawarire, including politician Job Sikala, who have been accused also of the same offense of trying to overthrow a constitutionally elected government. These things never go anywhere. It's usually done in order to harass the political activists and to harass civil society, to arrest and just make life difficult for them and intimidate everybody into not dissenting from the government's voice. So this is what many people might have expected in the case of Hopewell and Jacob Ngarivhume, that they would be kept in jail maybe for a few days, maybe for a week, and that after the 31st of July demonstrations, they would be released and they would be placed on these very stringent conditions where they would not be able to engage with the wider public, including on social media. But this hasn't happened. On the contrary, the state appears to have taken a very tough position against the two, and they have kept them in jail. And it's nearly 4 weeks now since they were arrested and detained. They are also receiving very special treatment. When I say special, I mean very tough, very terrible, very horrible conditions to which they are being subjected. They were recently transferred from Harare's remand prison, which is in central Harare, to the maximum security prison, Chikurubi, the notorious Chikurubi prison, which is on the outskirts of Harare, where they are now mixing with convicted criminals. Chikurubi is a notorious prison. It houses some of Zimbabwe's most dangerous criminals, and that is where they are keeping Hopewell and Jacob Ngarivhume. Even though they have not been tried, even though they have not been convicted, they are actually being given treatment which is worse than treatment given to normal prisoners. The main challenge has been to get them bail. Now, under the Constitution of Zimbabwe, bail is a constitutional right. There have to be very exceptional circumstances for the state to hold someone in prison without admitting them to bail. But the case of Hopewell and Jacob has been treated very differently. It's almost as if someone is guilty before they prove themselves to be innocent. When they first appeared before the magistrate on the 24th of July 2020 for the bail hearing, the magistrate's judgment was that they should be kept in jail at least until the 31st of July 2020. In other words, his condition was that he could not allow them to get bail because there was a risk that they would continue agitating for the demonstrations, continue mobilizing people for the demonstrations, and therefore they should be kept in jail for that reason. Now, Hopewell and Jacob's lawyers appealed to the High Court, as should happen. They appealed against the ruling of the magistrate. Unfortunately, this hearing was not held until after the 31st of July. So essentially, they fulfilled the condition of, being kept in jail until the 31st. You would expect that they would be released because the demonstration day arrived and went. There were no serious demonstrations because they were thwarted by the security services. However, they were still kept in jail. By the time they went to the High Court, the judge of the High Court was not able to hear the matter on the appointed day for the reason that the court record from the magistrate court had not been transmitted to the High Court. Now, this is not a fault of the accused. This is a fault of the administration of justice. But they were being punished for it. So the judge postponed the matter to the next day. And then when they met again the next day, the state then predictably, because that's what they always do, made an application to the judge to say that they needed more time to study the court record and to study the application, which had been made by the two accused lawyers. And the judge agreed to give them this postponement. It was postponed, I think, for about 4 days. So the matter then was heard on the Monday, 4 days after the postponement. And when it was heard, the judge then reserved his judgment, and he said that he needed 4 days to prepare the judgment. And so that was another delay. Now, we are talking of bail, which I said is a constitutional right. You want it to be dealt with as fast, as expeditiously as possible, because it is the freedom of two innocent men which is at stake. But the system of justice was just dragging its feet, using the legal channels to say that, look, we need a postponement, look, we need time to prepare the judgment. And of course, when the judgment arrived 4 days later, the judge upheld the position of the magistrate. It upheld the order of the magistrate and denied bail to Hopewell. And the next day, of course, it was Jacob's case. It was also denied on the same grounds. The denial of the appeal by the judge was very disappointing. The judgment itself was a very disappointing judgment. It was a poorly reasoned judgment. I shan't get into the details of the judgment in this podcast. I shall do that another time. But essentially what it meant was Hopewell and Jacob had to make a fresh application for bail at the magistrate's court. One of the grounds which you can bring when you bring a fresh application is to say that the circumstances have changed. Clearly, in this case, the circumstances had changed because the initial refusal of bail was based on the belief that the two men were going to continue to lead demonstrations which were scheduled for the 31st of July. And now that the 31st of July had come and gone, that was no longer a reason which was good enough to keep them in jail. So this was a good case for demonstrating that circumstances had changed. Meanwhile, the two men were being subjected to quite horrible treatment. So they also wanted to bring a number of issues before the court to demonstrate that they were being denied food from home, which all prisoners who are awaiting trial are entitled to, that they were being denied warm clothing, that they were being kept in leg irons for most of the time, that they were not allowed literature to read from home, that they were not allowed to see people who wanted to come and visit them as freely as the Constitution allows. And again, importantly, that the conversations between them and their lawyers were being listened to by the prison authorities, which is unconstitutional because the Constitution specifically protects the rights of the client to see a lawyer of his choice and to talk to them in private. Now, when the day of the fresh bail application arrived, the accused persons, Hopewell and Jacob, and their lawyers were told apparently that the magistrate was unavailable. But in the meantime, there was an application which was submitted by the prosecution to the effect that Hopewell's lawyer, the celebrated and courageous human rights lawyer Beatrice Mtetwa, should not be involved in the case. In other words, should be disqualified on the grounds that she had disrespected the court, that she had breached the rules of the court. And the reason for this, apparently, according to the prosecution, was that she had posted something on Facebook which was denigrating the justice system. The Facebook page, which was being referenced to in this case, is a fan page. Beatrice Mtetwa, as I said, is a well-known human rights lawyer who has won numerous awards and is recognized around the world as one of the best human rights lawyers, and she's done incredibly well. There was a film which was made in regard to her career about 10 years ago, and a fan page was created celebrating the film and discussing the film. And someone posted on that page, in fact, the owner of the page posted something about the case. And the prosecutor was saying Beatrice Mtetwa is responsible for this page, is responsible for this comment, which was obviously an absurd argument. But what this meant was that more time was spent discussing and arguing whether Beatrice Mtetwa should remain on the case. Now, this is a clear attack on the right of an accused person to a lawyer of his choice, in this case, Beatrice Mtetwa. The state is essentially trying to choose a lawyer for Hopewell Chingondo, to say you should not have Beatrice Mtetwa as your lawyer. They would rather he has someone else. This is a clear attack on an accused person's constitutional rights. Anyway, the case was heard, I think, over a couple of days. The magistrate, when it came to making the decision, then said that he could not make the decision on the spot. He needed time to research, and unfortunately, he did not have Wi-Fi at home, and he would have to come back to the office on Monday in order to do some research before he could give a judgment. Now, you can see what this means. It's another weekend in jail for Hopewell and Jacob. The case is delayed. Meanwhile, the bail application is not being heard, which is the main case. This is all about delaying the case as much as possible. So why is this being done? This is being done, of course, as I've already said, to deprive Hopewell of an opportunity to have a lawyer of his own choice. But more importantly, it is to delay the case for as much as possible and ensure that they keep Hopewell and Jacob in jail for as long as possible. Now, this is a problem in the current conditions of the COVID pandemic. Exposure to contracting the COVID-19 virus is very high in confined conditions such as the overcrowded prison cells in Zimbabwe. And so Hopewell and Jacob, the longer they stay in remand prison, in this case in the maximum security prison, the higher the risk they have of contracting COVID-19, which is a real problem. This is why this is such a callous process of delaying the justice system. The two gentlemen have also been denied access to protective clothing. They are also exposed to violence. The authoritarian regimes have a tendency of sending what you call pseudo inmates into the jail, into prison cells. These are not really suspects, but these are people who come in to spy on political inmates and might even cause violence. And some people might even fear, poisoning of the food that these prisoners eat. So there is a real risk for these two men in jail at the moment, who should not be in jail, because they are being accused of something that is so spurious. They did not call for violent demonstrations. They were calling for peaceful demonstrations, which are guaranteed under Zimbabwe's constitution. And in any event, the reasons for refusing them bail no longer hold any water. They've also submitted applications to the High Court. In fact, this application was heard and granted by a High Court judge. It was an application to allow them the opportunity to see their lawyers in private, the opportunity to get food from home, the opportunity to get protective clothing to protect them against COVID-19, and a number of other benefits which prisoners in their situation should be entitled to. The problem with the court order was that it was conditional to what they call the reasonable administration measures. In other words, they were allowed food, but in accordance with the reasonable measures that the prison might wish to impose. So what essentially the court order did was no different from what the constitution already allows. And it has left the prison authorities with the same amount of discretion that they have used, and used unreasonably in the past. And this is why, even after the order, they refused these gentlemen an opportunity to get books that they were asking for, to get warm home-cooked food, which they were asking for, which really makes a mockery of the justice system. I have not gone into much detail as to the real reason why Hopewell and Jacob are being kept, especially in the case of Hopewell. It's mostly because he exposed corruption, which is rampant in the current Zimbabwean regime. The most important issue which I wanted to cover was to demonstrate the horrific treatment that they are receiving, which no one, not even a genuine suspect, a genuine accused person who has committed a crime, should be subjected to. The Constitution of Zimbabwe does not allow this, but the system is not willing to abide or comply with the Constitution, which leaves Hopewell and Jacob in serious danger, like I said, of contracting COVID-19, which would be a serious risk to their health. And also the state is using these two gentlemen as symbols of what they can do to anybody who wishes to express dissent against them. And this really is the big issue as far as Zimbabwe is concerned. So I hope that the podcast gives you an idea as to the conditions and why Zimbabweans continue to say Zimbabwean lives matter, why Zimbabweans continue to ask for freedom for Hopewell Chingono, why Zimbabweans continue to ask for freedom for Jacob Ngarivhume, and also for other political prisoners who are currently held in Zimbabwe's jails. Thank you very much. I will come back with another podcast in the next few days, but I hope that this will have helped you. If there was a little bit of noise at the end of the podcast, it's because I am recording this in my car, and it's raining. It just started to rain just as I was finishing my podcast, but I hope it doesn't disturb you that much. Keep well, and please continue to tweet with the hashtag Zimbabwean Lives Matter, hashtag Free Hopewell, hashtag Free Jacob, hashtag Free Kurauone. Thank you for listening.